Good afternoon.
Mr. Olapide, you can proceed with your case. So you can present your witnesses or your exhibits or whatever. And so who are you going to call as your first witness?
Your Honor, I don't have any witness. I want to thank you for allowing me to represent myself proper and for accommodating my inadequacies.
Okay.
I apologize for submitting the exhibit list late, but I will present my case without those being admitted with openness and the best of my ability. If you give me the go-ahead to do so.
Okay.
Well, nice to be sworn in, actually.
You can you can present your own testimony. Do you want to do that at this time?
Yes, sir.
Okay. We'll have you raise your right hand, be sworn in.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Okay. Go ahead, sir, and tell me what you'd like me to be aware of.
Yes, sir. Based on what the plaintiff and the prosecuting attorney presented, I saw this case in three different areas: financial situation, domestic issues, violence, and my son's case, given him as the person they called to come and testify on our behalf. I tried while doing the cross-examination to clarify the financial situation, in which my wife tried to muddy the waters, claiming that my checking account is a joint account, which I refuted. In effort to muddy the waters, she claimed that three things rather. My salary comes into the account monthly. The rental payment comes into the account as income, as well as the tax rebate when we get refunded. If the math doesn't add up, you know that there's a lot of problem. And I associate this to a little bit of cognitive dissonance because I have 4 accounts with the bank, Homestead Bank, which is a family account. My salary account, checking account that I opened in 2006, I added out to it when I was planning to go to Morocco for 2 months in 2008 or 2009 to the check, sorry, not to the account. So there's a statement and my name is there. The other account is the mortgage account, where both of us signed the mortgage. I actually got additional 20,000 to do the roof 2 years ago. So our name is on there. That's the only one our name is on. There's a third account, which is the CD that I opened from my summer teaching and remittances from my research as an investment, which I told her. So I did that because I have a 9-month contract, but they pay my salary 12 months. So you are responsible for your summer salary. So I always teach a summer class or do first-class research. So money from that, I use that to do CD. The last one is the account I just opened in March, late March, for the 2020 Range Rover, which is a loan that was given. So the only thing going into that account, to the income flux that goes into the 4 account, is my salary, where all the other funds are being paid directly. So if she's claiming that the money the renters pay monthly, which the renter for the Ohio house was less than 500, let's say 500, which is barely 6,000 a year, and from there where we pay mortgage, all the time pay repairs, we have to repair every year because it's a Section 8 house where I have to pay. So before they renew the contract, we have to repair. I pay. Guess who does the repair? The brother, the immediate brother, Chaskepo. I have the evidence there. Anytime anybody moves out, we have to do overhaul. At times I spend 10,000. She will remember that it was flooded, in which Chip got there, the house was flooded. We pay over 10,000. We got some insurance rebate for that. So it just doesn't end up that in a household here where our average cost per month is about 3,500. You are saying that it's a joint account because rental money comes in, as well as the money that we get from federal tax refund. Guess what? Anytime we get that, I split it in half. I give her half of the money. This past year, and Your Honor, the court has the evidence of the tax last year tax refund. We owed 3,000. I joke about it. I said, well, since when we make money, we share it. Give me 1,500 of this. It became a fight. I think it's cultural differences or views that makes us to conflict. What my wife calls abuse, I call discipline. Or when I joke, she thinks I'm making fun of her. This is what just occurred this February before she moved out in March. So that I refuted or disagree with the issue that my checking account is a joint account. You will remember now she will never mention what she does with her own credit card account. She has my name on the checking. I cannot tell you the color of my wife's checking account or checkbook. Whereas I will look my own checkbook here or by the bed, she always put her own in the bank, given experiences growing up in which she told me that adults will steal people's money. So she always guide her money very closely. So I have no problem with that, except that now she's claiming that my salary now becomes our salary. And the question arises, since we've been together, she's been supposedly working, what happens to the salary? She claims that we spent it on the house, but the statement, the credit card statement that they presented is just for 5 months, January to May 2024. Are they claiming that the 42,000+ were accrued just this year? Because I can lay aims or lay claims to 7 years of my credit card statement. If I want to prove that I spent something somewhere, I would present that. For example, the tuition, my daughter went to Indiana Tech where everything was about 52,000. My wife accurately said the tuition was, due to tuition exchange by my affiliation with Abion College. But I paid for the room and board, and I put that on credit card, and I can show you. In fact, when I was preparing for this, I have all this from 2019 up to now, so the proof is there. Whereas if you just oppose that to the 1,000 or 2,000 that she talked about, that she paid for the school trip I'm not saying she didn't do that, but that doesn't add up to the 42,000 that she was claiming she spent. The same time, around 2020, my son had an accident on his bike that the insurance payout was about 8,000. We did not have insurance then. I paid. I didn't complain. She's alluded to that I had to pay. Given the financial situation, I was trying to share when I was questioning that it has to do with our, not, holding us to the agreement. Like I said, when I finished my PhD, I was supposed to graduate in 2003. I delayed my graduation to 2004 so that we can have insurance to cover us before we have the baby. Shalina had insurance through University of Akron then. And as I was doing that, I had 2 postdoctoral appointments. One at Yale. Yale offered me a postdoctoral scientist position, but they only insured me for 2 years. University of Wisconsin-Milwaukee gave me 3 years, but they will insure the family. I intentionally delayed going to Yale in January to July 1st to go to Milwaukee so that we will have the baby. Again, Shalina had insurance through University of Akron. When we got to Milwaukee, I already went before them. After I graduated in May, they came in 1st of July. We had the Humana. The house, we just bought the house less than 2 years before then. It was empty. So I was paying the $450, paying the $725 in Milwaukee, and all the associated bills that has to do with the house in Ohio. Your Honor, I think at this time I will talk about first abuse. I've only had 4 incidences with the police. The first one was when I was waiting to start my doctoral studies at Kent State, in which I was walking along the shores of Lake Erie, and I was confused. I didn't know where I was. I saw a cop. I flanked him down, and he gave me a ride. And I saw he had for my ID, and I saw my information on the screen. I was very, very intrigued. I didn't know that a cop can get somebody's information like that. That was the first incident. The second one, my wife talked about that when we first moved to the house, she had to call the cops. I didn't know that was an abuse, because if she will recollect, that was a week or 2 after my father was visiting us for the first time from Nigeria. My father left the US in 1980 after his PhD. He's never been back. Shalina will validate that. My mom has been there 2 or 3 years. We just bought the house my father came. Shalina told me on a Saturday she was pregnant with Ayo that came to testify today. She was going to the flats in Cleveland with her friend. We kept calling. We called Raven, and the mom said she wasn't there. She said she was going to the flats. We went to bed until the cops woke up us and said that we won't let her in. So I was surprised because we locked the front door, but there are 2 other entrances from the kitchen and the bathroom in the back. There was no abuse, except if she's claiming that myself and my dad abused her. If you remember, my father left the guest room for her that day and slept on the couch. So when I had this December, I thought I abused her. That was the first time a couple come to my house. There wasn't any argument. The cop just said, Mr. Lapide, let her in. I said, we were sleeping. It was 1 a.m. I can't even remember. I would not want to make up any time. The second time was when in 2001, I was going for sabbatical to South Africa. And I don't know where the argument of the 4. Oh, that was when the pastor's wife, just a few weeks asked me about job opportunity. She just moved from Atlanta, a first lady, the pastor's wife, to the church. So I used to go to the church infrequently. So I said, Shalina, first lady asked me for the job position. They just advertised this job. Well, why don't you apply? We met through Upward Bound. This will be the opportunity for you to, contribute to the college, and the job is good. The director position that she left after 1 year. So that was the argument about the 401k. So this was an argument for weeks in which I called Miss Nora Jackson, the senior sister in our church. She came here, and the confrontation was she didn't want me to go to the church or call the pastor's wife, so we were fighting over the phone. And like you said, she called Officer Collins. Officer Collins met me at the church while I was talking to the pastor. I was excited when I saw pastor's name on the witness list for her, because I would have been able to clarify what I was discussing with the pastor. Officer Collins didn't want to arrest me. I admitted that, yeah, we're fighting.
Objection, speculation regarding what Officer Collins did or did not want to do.
I asked the officer that.
No, sir, you can't speculate as to what the officer did or why he did it or didn't do it. You can only you can only testify as to what you observed.
All right, sir. The officer told me your wife.
Objection, Your Honor.
Sustained.
Okay, sorry. I'm sorry. I apologize.
You can't say what he said either. That's all hearsay.
All right, I apologize. So that was the first time I was in jail for the 401k. Now I can say I've been, vindicated, because I knew something was wrong. Shalina, Where's your retirement? Where your retirement benefit? I always put mine down, the Albion College retirement that she wants to go after now. When we do tax, Shalina, where's yours? You have a master's degree. See, where did, she said, oh, they never gave it to me. Community Action never gave it to me. I will get it, I have it. Until December 3rd, when Anthony McNeil said that she spent it. I wasn't aware. I didn't know she spent a 401k without my knowledge. So that would be the third time I will be in charge of in presence of the police. The last time was when Olaide was here this past December that I was asking for my son, Ayo. And she said I made him leave the house. I said, how could I? I was in Nigeria. When he left, the last thing he told me was he was going to talk to the Honors Institute. He was already been admitted. But before then, I knew some changes. That's why I used the word weaponized. And I'm glad my son used the word that it wasn't weaponized, because Shadna will come and tell me, give Ayo back, because we had some things we exchanged, wristwatch cases. Give it back to him. I said, let Ayo ask me. Or when they brought the pastor, I said, what? Like I said, maybe it's cultural differences. I am a professor. I wanted my sons to do well. Now he's doing menial jobs. They told me he's an adult. I hope he goes back to college. He was admitted. There's a conflict between parental responsibilities and child rights, which probably caused this problem. For example, the braid he had in his head, he would never have that on his head if he were to be in my house now. I've not seen him in months.
Your Honor, I understand that the court's giving Mr. Lapide a great deal of leeway, but the fact that his son had braids in his hair has absolutely no relevance to this matter.
Well, I understand. So, sir, stick to what's relevant. I'm not deciding anything with regard to your son or what the reactions are. I will only address at that time. I'll only address his testimony. So please confine yourselves to that.
All right, thank you, Your Honor. So, I was trying to show that those were the 3 or 4 incidences with my contact with the police officers. Well, the last one was when the 10,500 was withdrawn without my knowledge, and I went to report, and the police told me, this is getting out of hand. You better...
Objection, Your Honor. It's hearsay.
Oh, sorry. I'm sorry. All right. So, yeah, those were the issue of, the financial situation. And then with the issue of, unemployment, we fought over that. Pastor Kendricks of blessed memory, you don't have to work for a school system. You keep saying that your certificate cannot work in Michigan. There are other jobs. I have a colleague here. The wife has a PhD in genetics. She's the administrative secretary of a department, a PhD from MSU. And apart from that, what overrode that was you got the job making 50,000. And for that year, show what that was used for, especially in light of you presenting a $40-something thousand debt, or say your car is 2006. The grant was for 5 years. The person that replaced her is still there till tomorrow. So we have to look into the issue of responsibility, ability of not being able to maintain a job or working away. I think she only mentioned that she was sacked by the Calhoun County School once. She left community action on her own. The issue of Nancy, she told me after weeks that, she said I complained about Nancy. She would tell me Nancy would tell her to come to work on Saturday. She won't show up. She would tell me she will go to school. There will be no toilet to go to. She will complain that she's tired of driving to Jackson. So those are reasons that we should not, excuse an adult. And when she said, I said, what about if she's single? That's what I said. If you are single, won't you pay your bills? I've met her since 1999. I've not defaulted or not bring a bill, paycheck out or in every month. So you cannot just walk away because you have a spouse and believe you can just walk away from a job. When I bring this up, you said, you're always home on weekends. You don't go on in summer. When I teach virtually, asynchronously, virology, other classes or supervised students, she knows that. The evidence I was not included, I had all my grants that I write every year. For example, my that professorship, I'm giving 10,000 to travel every year. It's based on what I said I was going to do. So when she said I go to Tanzania, I go to Kenya, I'm studying all these oceans as part of my research. So I just don't up and leave just for fun. And she even admitted today that we travel for my research. Gulf of Mexico, Monterrey, all of these places we've gone together as a family to do that. So those are the issues I want us to highlight. And then saying that, why I was paying Olaide's tuition, paying against almost $10,000 medical bill when we didn't have the insurance that we sat down as a family to say, well, let me maintain all of these other bills while your job. That's what a lot of couples do, especially when you work in a very small school like Albion College. Couples will split responsibilities like that so that they are not overburdened. So a lot of our fights, to be candid, justifiably or not, so either based on discipline, financial security, or lack of doing the right thing. That's why I use the word cognitive dissonance. When you just believe in one thing, which is what occurred at Albion College, saying the college wasn't run the same way and you left a $56,000 job. When you are in debt, and I asked her, did I know about this debt? I did not. And if this debt is there, and you are claiming we have a joint account, you never wrote a check to offset it. She doesn't have a checking account from Upstate Bank. She doesn't have a debit, the 2 ways where I get money. There's a reason why she used withdraw draft because she has that's how she knows the tracking number, the check I gave her for Olaide. So the only way she could withdraw money because she doesn't have any other sources was to use bank draft when I travel. And you should question the rationale for leaving when I travel. The same way she moved Ayo out exactly a year when I was in Nigeria. When I was in 2003, she left the same week. I started telling the court that she did not know I was traveling. That is not true, Your Honor. Before I traveled, Akin my youngest one wanted to travel with me. I said, Akin, he said I should take him on a cruise ship because we were talking about this cruise ship since 2023 when they graduated. I have a lady to organize. I said, go bring your passport. Say I can't find it. So I went to where we kept it. He said, Mom has it. Shalina, where are the passport? Including Akin is the only one that has a Nigerian passport. My wife took all the passports, including Nigerian passport I got for my son. She still has it with all of her documents. I forgot that the passport expired. That's why I went to Colombia alone. I wanted to take my son Akin with me. That was when I knew that she already seized all the children's passports. She took all the passports, both American and Nigerian. Akin has a Nigerian passport for over 10 years that he has never used. I got a passport for him because he's the only one that's never been to Nigeria. Shalina has been to Nigeria twice. Oladi has been to Nigeria twice. Ayo has been to Nigeria once. My father keeps saying before I die, bring Akin to me to come and see me. He even said this Christmas Day. So she took that with her. Ayo testified that due to the issue with Shalina, it was a fight because I wanted Joe Bila to finish the work. We already paid a down payment of 5,000. They were waiting on Shalina to pick all the ties she wanted and the like, and they kept getting delayed. And there are a lot of holes in the house in the toilet. And I said, Shalina, let me handle with these people. I will not pay them the last money until they finish. She went back, just like Ayo said, to go and give them thank you card to be inviting the wife. I said, they've not finished. The hole is still there. So we're fighting over that. That was what Ayo witnessed. So it's always an action reaction. To every, there's always a cause and effect. I always react. I'm guilty that I overreacted. I react at times, just like I overreacted the last time I was locked up because I've not seen my son for a year. Any parent would do that. This is a son that was thinking he was going to come to college, study dentistry. Before he said he was going to go read dental hygiene, I said, Ayo, you already have an associate degree. Come and study biology. He said, well, Olaide went to Indiana Tech. I said, you cannot we have to look at the budget. Come here, Albion College, you will be home, you will keep your job at the bank, just like I said when he came here. Again, it's not out of abuse. It's probably part of the love of a father thinking. I couldn't tell my father when I was growing in Nigeria, he's a professor too, that I wanted to go to another school because he couldn't afford it. So the Olaide thing, you can't be comparing, just like you said, Olaide did an open house at a place where we paid $100. We have to do that. We can't continue that. All of our friends do this in our own house. China said our house is not big enough. I hope they can see the house. We have one of the biggest finest houses here. And open houses is something they do all day. Why do we have to go pay $800 in a place where they only give us 3 hours? That we have to move things in. When we did the Olaide, China, I forgot to mention, the leftover barbecue poured into my car. I spent over $1,200 to replace the computer unit.
Okay, sir, if you could speak slower, because it runs together and I'm having a hard time differentiating. So speak slower if you could, please.
Thank you, Your Honor. Yes. So my suggestion that we should not go to that place to do parties arose from my experience a year before when Olaide, my daughter, had her own open house there. When we were cleaning up, I was bringing up leftover food. The barbecue sauces poured into the seat of my Mercedes, and I had to spend over $1,200. I said, why can't we use our house? All our other friends in the community uses their house. Without even knowing my wife had this debt. Why do we have to go pay? I had to come up with her $400. I had to cook all the fried rice and jollof rice. She realized overnight, we didn't sleep. We could do it here. She said they will come here and dirty the carpet. Talking about cleaning the house, I'm the one that will vacuum and use the steam to to vacuum the carpet. And they said I don't do any cleaning. I intentionally, so that these kids know how to do chores, refuse to repair the dishwasher. I said, wash the dishes. When they say I wake them up, I remember when you gave us a break, that I wake Ayo up. I said, you are going to college. You need to wake up and study. My son doesn't have notes for math, no notes for biology, so that I can help him. When he said I want to take it, I did the same thing for Akin 2 weeks ago when he didn't show me PSAT results for almost 2 months. I paid for it in October. The result came, he didn't tell me. I will wake them up to study. I said, you have a quiz, you need to study. I imbibe that, seeing my father studying for his own PhD. So again, I do things that a loving father should do. Because I wake them up is not to do anything. You told me Dr. Mr. DeLong talked to me that you didn't turn in this assignment. Well, do it. Do it before you go to school. Those are the kind of things I do. And I say this because I teach 18, 19, 22-year-old. We have students that cannot wake up on their own. We have students after one semester. I've gotten 4 rusticated, letters this month. You pay $25,000. You're gone after 1 semester, and the evidence that I submitted late.
Your Honor, well, it's very interesting what the students are doing. I don't find what the students at Albion College are doing is relevant to this divorce matter.
I will sustain that. Sir, stick to the issues. The issues we have to deal with are property division,
All right.
also support, attorney fees,
Yes.
and debt. So stick
Thank
to
you.
those issues.
For the property division, when we bought this house in 2012, I put down 32,000. I gave Shadna the power of attorney because I was going for sabbatical in Sydney, Australia. She did not contribute anything to that. She's here to refute that. I don't have any problem with dividing the property. I have problem with dividing my 401k, given that she's already spent her own. I have problem with giving spousal support because she has a master's degree. She should be able to work. I have a problem splitting my 401k. I think I said that, because I don't have any proof. I don't see our own being tabled to be discussed or to be split as it should be equitably. And lastly, I hope I'm not the credit card. I have no clue. I don't know how anybody could. I don't even know it was possible because I wasn't told. That was the reason Anthony McNeil will remember that was the reason I said I was out of that mediation when they presented me with a 42,000 credit card debt. I've been in the US going to 30 years. I never knew anybody not to talk of somebody I've been living with for 24 years. So I have my name is not in any of our credit card. We've never, jointly owned credit card or account. And I don't think I should be responsible for an irresponsible financial behavior. Adults need to do the right thing. I've always done the right thing. I've always maintained my job. If I want to change jobs, I get another one before I proceed. I remember from December 3rd, Anthony McNeil asked if she was aware that I was going to Iowa. I probably wouldn't get the job here at Albion College if I did not go to that Iowa, because she would remember that even they flew me to Florida, Florida A&M. It was either there or here. And she also alleged that I was shouting at people that was about to employ me. How can that be so when they even housed all of us in the Manor House before I got this job? Shadina didn't want to come here. She preferred me to take the job in Florida. She said, how could we leave Milwaukee to come here? So these people, she's not aware of, like just like I'm speaking now, my tone may be tonal, but not accusatory. I'm not litigious. That's why I don't have a lawyer. I don't spend out of my means. I've spent almost 10,000, including the lawyer fee, 1,500 that you told me to pay when my attorney defaulted, which I'm seeking redress. That's why I'm representing myself now. We have a 16-year-old about to go to college that we should be saving for. We are not doing that. Adults should do the right thing. We should be putting our resources in a more productive way. We may claim, given the American culture, that they are adults, but they need the parental support or direction or directives should be, there to guide them to do the right thing. So I'm worried about acting, securing a good college, being able to, just like we did for Lide, rather than, being litigious, spending money, spending assets that is not even there. So we have two parties. Where we are one being responsible, trying to maintain normalcy, financially, and so the other one always coming with excuses. And the emblematic one with the issue of who walks away from a $50,000 job. My wife will tell you that she is always scared when I sleep because I have sleep apnea. And that probably with a lot of other things that has been going on since separation led to high blood pressure and high cholesterol. I am not diminishing her health problem. She has been saying, at times she struggles, but you don't have to pay the bills. Nobody will excuse you from responsibility. So when I come home, I don't go out. She will complain I'm always watching TV. I'm staying out of trouble. I don't want to be going to bars, drinking and do like that. I stay home. You say I'm hugging the TV. We had 3 TVs in this house. It was because I don't want the kids to be watching TV and not study that I will remove one. So we have one in the basement. We have one here. I always most likely stay here because this is where I do my work. So if you do, damn if you don't. So I hardly go out. But the issue is if we work together, we will not be in this problem. Let me know before you leave a job. It's always excuses. And these are not tenable excuses because excuses will not pay the bills. And again, I hate to say I'm vindicated. Now this is the bills we now have to deal with. I wasn't even raised. I was almost 30 before I came to the US. So I wasn't raised in the capitalistic system like this. She's talking about me sending money home. I will give you reasons. I have a dad that's almost 90 years old. He lived there in the 70s and 80s. My mom died 5 or 6 years ago. He doesn't need my money. Shadina knows that. But when I go home, it's very costly to be changing. And now Nigeria is moving from, towards cashless society. So it's become very difficult to get money when I get there. And she didn't know from a second source. I told her that I just opened an account. Like I said, I've been in the US since 1996. I just opened an account in January. She wouldn't know if I didn't tell her. So sending $100 here, $100 there, so that I have a kind of identity. So that I don't get, the last time when I went, I had to call my sister to pay for my hotel bill in Lagos. So you cannot weaponize activities just because, you disagree with them. I'm an adult, I'm 57. So, and I have, when even she will be the one to help me when I want to take gifts home. They look up to us to give them gifts. So, I don't know what to say. So the issue, Your Honor, I'm about to round up. My talk is on financial situation, domestic issues, violence, and Ayo's case. Of all of these, the one that really, really tore me up is my son's case. You know, it really did tear me up because it's very promising. Nobody would even tell me, thank God for the trial. Maybe that's one of the positive from this trial. I wouldn't have known where he's working. You know, where's Ayo? But I can say he's fine. Where he changed his job. I went to Sam's Club last year 4 times. He wouldn't see me. Say, Ayo, I am here when I'm healthy so that you can go to school without, being in debt. He said he would do it on his own. And the evidence I couldn't submit shows all the delinquencies. So, Your Honor, I rest my case.
Anything else?
That's it, Your Honor. Thank you.
Okay. Any,
Your Honor, please, I forgot something. Please.
Okay, go ahead.
My wife said she left this card and the credit. This is the card for I put 1,000 there for what do you call it?
This is being streamed. I don't think it's a good idea to show that on.
Oh, sorry. Yes, thank you, Attorney McCain. She left the card when she was angry. The same way I pay for all the phones. I bought her an iPhone. We had an argument. She left the phone and she wanted to get another phone. She went to get Verizon. So I pulled everything together. And with the insurance card, the insurance still covered that till 2 days ago. She left the card, but she was on the insurance with the college. And the issue that I selected one, I deferred to her because I'm glad that as a part of my evidence, they submitted that. And she said I had the mom was there. I came on one day when we were December, this time, November 2 years ago, when we were supposed to do the open period. Last time she was the one that did it because she was working at the college at 2022. I said, Shalina, I was trying to renew our insurance. I couldn't find your name. She said I did it. So that was the argument we had. And I said, I don't even know how to do it until human resources sent it to me. And I had the name. And then when the college was trying, it was the college that was trying to tell us to do the high deductible because the colleges pay more when you do the PPO. They said if you don't use insurance, at that time she didn't have this cancer diagnosis. The college were literally, because I don't know, maybe I couldn't say this in the court, going through some financial issue. They encouraged all of us to take the high deductible if you don't use insurance, so that the premium or the thing the college pays will go down. And I asked her, the same one we had is the same one they just transitioned to this year. I don't have to have insurance like we didn't have for years because I don't use the insurance. She knows that until they diagnose me for high blood pressure this December, I don't go to doctors. Even now, it's my student that's my doctor, my former student. My doctor is my former student, graduated in 2008, my dentist. The only time I saw her to go renew my prescription, my sleep apnea, I don't even use the instrument. And now we say she would think I would die because I can't breathe. That's my major problem. High blood pressure. My doctor said she thought I was having a heart attack. When they measure China knows that my high blood pressure went up. She said, am I having swollen legs? I don't go to doctor. So how can I use that to use as a punishment? I pay, like I said, I was surprised. We are paying half when you work there for a year. Why do you walk away from that opportunity? It just doesn't make any sense to me. So those are the kind of things that makes me flare. We work together. Let's work together. We are paying half. And the IO would have benefited with tuition exchange. Just go to where we can afford. So when I say, so people will say, oh, we drove a Mercedes, you want a Range Rover. They are always not new. They are always used. And they are always on loan. I live within my means. I don't have any debt. I don't want that to pay any of my debt. I don't want anybody. I wasn't raised like that. Thank you, Your Honor.
Thank you. Ms. McNiff, do you have any cross-examination?
I do, Your Honor.
Okay.
Mr. Lapide, your current pay for the fall and spring terms is $75,000. Is that correct?
Yeah, that's my contract.
And then you said that you teach one summer class?
Yes, I always teach a class, virology, to make extra money.
And how much money do you make teaching that class?
So it's variable. At times, there will be 4 students. Like this last one, yes, 5. They pay 400. They give you a minimum base. If you have 4 students, they pay, I think the first 4 students is 1,000. If you have 5, 6, 7 students, you get 410. So it's variable. I've taught it with 3 students. I've taught it, I think last time was 5 students. So if they pay you 1,000 per each student, that's 4,000 and 410. So it will be 4,410. So it's usually, you cannot gauge, you cannot gauge how much it will be. It's based on attendance.
Okay, so $1,000 per student.
Yes, the first 4. Everybody gets 1,000 for the first 4. If you have more than 4, it reduces to 410 per additional student.
Okay, so what's the maximum you can get?
I think the maximum, if you have 16 students, like 8,000. If you do the math, I have the email. They just sent it out for next year. I can forward it to the court. Okay, I've never taught more than 5 students.
Okay, so it would be the least you would get would be 1,000 for one student, and the most
one student
would be 8,000.
Yes, the maximum they can pay you is 8,000. That's what I'm saying.
Okay.
You can have as many students as you want, but the school will not pay you more than 8,000. I may be wrong, plus or minus some dollars, but like I said, Darren Mason, my colleague, just sent the email for next summer.
And you said that you always were putting that money into your CD account?
That's what I use for this particular CD, as well as, I think I have a letter with the GSEA. They will put me, so they gave me 2,005 to travel this May. I will fix it, then I will use it to travel later.
Okay.
So these are things I do as a financial, and I told my wife. Another thing I do,
And
which
that's,
I'm
and
not
that's, so that was my entire question was just what you make for the summer class. And,
yes, I wanted to tell
if
you
you
the top
put it
thing
into
I
the
do.
CD.
The
Okay.
other thing I do is I get what we call FDC grants to travel. I tend to go on those trips with me.
Okay.
We
Now-
went to Florida together. We went.
You're going way beyond what I asked.
Okay, sorry. Yes.
Okay. So you agree that you want to keep the marital home, correct?
Well, I think
Do you want the
based
court,
on,
do you want the court to award you the house?
or we sell it and split the thing because I don't want to be tied down with a very high loan. I'm saying that if you let me, 2 years ago when we got 20,000 to refurbish the house.
Sir, the question is very easy. Do you want to keep the house or not? Yes or no?
I depending on how much it's appraised for. That's what I'm getting to. It was appraised just 2 years ago for 170. Now they said it's 230. I don't want to go get a loan and the house doesn't appraise to that level. It's conditional.
So do you agree that it was appraised actually $200,026, $226?
Yes, but the bank disagreed because that appraisal was done by the lawyer. The bank's appraisal was 170. So I want to find a happy medium. We can sell it and split the difference. I'm still the one responsible for the house.
So are you asking the court to order that the house is sold?
Yes, if it's going to be sold at 226, if it's at 170, I will take on the house. I have no money to go get additional debt. That's what I'm trying to tell you.
Okay. Do you agree that the mortgage balance on March 1st of this year was $84,483?
Yes, I agree.
And so if we took that appraisal of 226,000, then the equity would be $141,517.
I agree.
Okay. So what I think I hear you saying is that you want the court to order that your house be sold and that you and your wife split the proceeds from that sale?
Yeah, if it's sold, because I disagree with the appraisal of 226. I told you that 2 years ago, the bank itself appraised it at 170. So that is where we are now.
Okay. And so you don't believe that the appraisal went up because you remodeled the bathrooms and that you fixed the roof?
The bank doesn't think it will go up by 50,000 in 2 years.
Okay.
So if it sells, it will both our profits.
Okay.
I will continue to maintain the mortgage. If it sells, I'll give her a half.
Okay, so I understand that you're asking that the court's order that the house be sold and the net proceeds split.
Yes.
Okay. You agree that your wife is getting the 2006 Honda Odyssey?
Yes.
Okay.
By the way, I paid for the down payment 2005 when we bought the house.
And I didn't ask you that.
Oh, okay. Sorry. Yes.
Okay. And do you agree that the value of that vehicle is about $200?
I don't know. I have to do the Kelly Blue Book.
Okay. And you agree that you're keeping the 2014 Hyundai Elantra?
It's for my son. I'm not keeping it. It's for Akin. We already agreed that it belongs to Akin. He drives it. I don't drive it.
Okay. Now he doesn't have a driver's license yet, right?
He's about to do segment 2 on Monday.
Okay. What I asked you is, does he have a driver's license?
He doesn't have. He has a learner's permit. He doesn't have a driver's license yet.
Okay. He has his learner's permit. He does not have a driver's license. Okay. And do you agree that vehicle is worth $5,000 and $5,971? I
doubt it because we bought it like 6,005. That was 4 or 5 years ago. So that value is overrated. The 2013 Hyundai, we bought it when Ayo turned 16. So he is 20 now. So 4 years ago. I doubt it will still remain the same amount.
And who's been driving that car?
Akin, the 16-year-old, the younger one.
I thought he doesn't have a driver's license.
He has a learner's permit. So he drives when somebody's there with him. Okay. Or what do they call it? Segment 1. He has passed segment 1. He has paid for segment 2. I just paid for his segment 2. He's going to do it on Monday. So
you don't let him drive by himself.
He doesn't. I said, somebody's always there with him.
Okay.
That's why, but it's his car. I thought we went over this before that the car belongs to him.
Oh.
It was bought for Ayo, but we're giving it to Akin.
Okay. I'm asking you the value of the car.
I don't know. What I said is we bought it around 6,005. It cannot still be 5,000 after 4 years. It's a 2013. It's 11 years old, 12 years.
And do we agree that the equity in your 2020 Range Rover Velar is approximately $10,000?
How do you come up with that equity? I see in the bank. I've only paid 6 payments. The car belongs to the bank.
How much did you pay for it?
I think I bought it 40-something thousand.
And you traded in your Mercedes-Benz for it, correct?
Yes.
And how much credit did you get when you traded in the Mercedes-Benz?
I think it was about 8,000 or 10,000. Yes.
Okay, so you've got equity of about 10,000.
I don't know how you do the calculation. I just know I still owe in the bank about 40,000.
Okay. Now you agree that in the homestead, so your position is that you did not have a joint checking account with your wife. Is that correct?
We don't. The only thing that goes into the checking account is my salary.
Okay.
We don't.
And do you believe that both of your names were on that account?
No, I have the evidence. Her name is on the check, but not on the account. I have a statement that shows Ola Olapade on the loan we got. Both names are there on the mortgage. That's the only thing she has with the bank.
Do you recall making a police report on March 12th of this year regarding your wife taking money out of that account?
Yes.
And do you recall telling the police that she took money from your joint account?
I did not use the word joint. I said she took money from my account.
And if that's indicated that you told the police that she took money out of the joint account on the police report that you provided as an exhibit, then the police got that wrong?
I did not use the word joint. I wouldn't have filed
Okay.
if I you know, it's a joint. That's what I've been proving since morning, that it's not a joint account. It's
And
a salary account.
And so you agree that your wife withdrew money and put that money into 3 certified checks, correct?
She withdrew 10,005 the day I traveled. The way she did it shows, you know, that, you know, something was.
So you provided some exhibits, correct? And you provided those exhibits on November 6th. Do you remember that to the court?
Yes, I did.
Okay. Do you have those?
I do. I think I do. Let me. Yeah. Okay. It's the. What are you referring? I have a lot of documents, but all the ones I have are the ones you have. Yeah.
So I can describe them for you.
All right.
You included a copy of a bank statement from Homestead Bank. Do you remember that? Okay.
Yes.
And you also included copies of withdrawal slips. Do you recall that?
I do. Recall.
Oh, okay. And one of the withdrawal slips said that on March 8th of 2024, your wife withdrew a sum of $3,957.27. Do you recall that?
Yes, that's the check I wrote to my daughter that
Okay.
she submitted and then canceled.
And she obtained a cashier's check for that same amount on that same date, correct?
Yes.
Okay. And she also withdrew in a separate transaction the sum of $6,929.25, correct?
Yes.
And $2,500 of that was in cash, and the rest was in a cashier's check.
Yes.
For $4,429.25, correct?
Yes.
Okay. And then she also withdrew in a separate transaction the amount of $3,567.37, correct?
Yes.
So, and she got a cashier's check in that amount on the same date, correct?
Yes.
Now, you believe that the bank would allow her to take money out of an account that was solely titled in your name?
You have to understand that this is a bank my son works at. Taylor and Jessica Jessica then goes to the church.
And hang on, Mr. Lapide, I didn't ask you about that part. Just do you believe that bank teller would allow her to take out that much money from an account that didn't have her name on it?
Yes. In fact, they told me when I was trying to lawyer up that I should sue the bank. It's a family bank. I didn't want to mess things up. The bank was the one that told me to go file a police report.
And what was your wife was your son working at the bank at that time?
He worked there until he left. They know him. And
Was he working there at the time that she
wasn't? But what I'm saying is, it's a small local bank. Everybody knows us there.
Was he the teller at that bank?
He was a teller there.
Was he the teller when she withdrew the funds?
No, I said he wasn't. But these are his friends. These are his former colleagues.
Okay. After your wife took those funds out of the bank, then were you left with approximately $3,125 in the bank?
Yes. And I transferred that to a new account I opened the next Monday or Tuesday.
Okay. And at the end of April of this year, would you agree that you had approximately $8,592.57 in your savings account at Homestead Bank?
I don't have a savings account. It's a checking account.
You have no savings account?
I don't have a savings account.
Was that potentially the CD? Did you have a CD in approximately that
Yes,
amount?
I told you, yeah, I have a CD, yeah.
Okay, and how much did you have in the CD then?
I have 15,000. That's what I told you. I had to eat as I make extra money. Okay. As I've been speaking now, I have 15,000 plus. Okay. I have a CD, I have a checking, I have the car loan, and we have the mortgage. The only thing account that has Shalina's name on is the mortgage that we signed together. Okay.
And you agree that your wife, that there was a joint Blue Ox credit union account?
I don't have a joint account. I have my name on a checking, just like I put her name on my own checking. I've never been to a bank.
Okay,
if I went to that bank, they will arrest me. I don't have a joint account with that.
You don't believe that your name is on a checking account at Blue Ox?
I do believe. Our name is on my checking account. I mean, checking. No, not an account. My name should be on a check because we put it here, Ola, or it's on the check, but it's not on the account. It was just something we did for convenience when I travel.
Oh, okay. And do you have any reason to believe that there's anything more than about $5 in that account?
I don't know anything about the account. I've never seen the statement. Never put anything in that account. Never withdrawn anything from that account. So it can't be a joint account. That's why I started my argument or questioning with what I believe or definition of a joint account is. I've never been to that bank, except when we are driving together and she wants to withdraw from the ATM. That's the only one time or two times I've been with her. I've never entered that bank.
So do you have a bank account in Nigeria?
I just opened one in January. The one I was telling you, Zenith in January.
And how much money is in that bank account?
I have to check. It's in Naira. It's less than 1,000 because the exchange rate is now 1 to 700. So it will be less than $1,000. I just started putting 100 every month.
Okay. And is there a Minnesota life insurance policy?
I know I have no idea about that. I have no. The life insurance I have is with Albion College. I don't know if it's through Minnesota, but I have a life insurance that the college, gives everybody. I've never used it.
So it's probably a term life.
I think so. Yeah.
One that has no
Because of the
cash value.
contract. Did they say 50,000? I please don't quote me.
Okay.
Because they remove something every paycheck, but I don't think of it.
Okay. And you agree that your retirement at the time, around the time that you and your wife separated, was approximately $330,811?
I believe so, especially based on what you presented. Yeah.
Okay. And do you have any reason to believe that that's not accurate?
No, well, the only thing is they are not all Albion College. I pulled the one from Pennsylvania. I was an instructor at Millersville University in '98. So that's before I met Shalina. She will tell you.
And that was before you were married, correct?
That's what I'm saying. Yeah. So it's not only
So that wouldn't be marital if you weren't married when you had that. Accurate?
Yes, that's accurate. I brought it. In fact, at Albion College, you have to have TIA, CREF, or you have to wait 2 years. I didn't have to wait because I already had from Millersville.
Okay. Have you had any? Do you anticipate any raises in 2025?
No, they've frozen all races except merit. I just have a paper accepted. If they always give us merit races or what we call bonus, if you present that.
Okay.
But with the current financial condition, I wouldn't take that to the bank.
Okay.
They are free. Last year they didn't give anybody anything, so I don't know if they will give anybody anything.
So in 2024, you received no bonus?
Nobody did.
Okay.
Yeah.
And I'm sorry, what month do those bonuses generally come out if you're going to get one?
Because I was on the committee that make the recommendation to the administration, it will be after May. We do the recommendation in spring, so it will be through the summer before our contract. Our contract normally renew every August.
Okay. Okay.
So it will be the intervening period when we recommend to the provost will recommend to the president will recommend to the board of trustees. So it's between May and July ending before the new contract. That is when new bonuses, merit, or races will come into play.
Okay. You agree that you were arrested in May of 2021 for domestic violence?
Yeah. May? Yeah, you are right. Around that time, that was the one at the church.
Okay. And you weren't convicted, correct?
I wasn't, yes.
Okay. And you agree that you were arrested in December of 2023 for domestic violence, correct?
Yes.
And you do have a conviction for that one.
I pled guilty. Because I was about to travel, the judge, in my own recognizance, asked me to
and I didn't ask why. I just asked.
Okay. All right. Yes.
You were in fact convicted. And so, do you disagree that there were other times in your marriage when you hit or slapped your wife?
We asked couples, but it was far in between. Yeah, definitely. Yeah, just like the arrest indicated. Yes.
Okay. You consider that discipline?
I consider that fighting, disagreements. I overreacted. I admit that I should not be overreacting, but especially in light of the circumstances I discussed with you, yes. So I would not say that I exonerate myself. Yeah, I overreacted.
So, and you agree that when your wife had the hysterectomy due to her uterine cancer, that you were out of the country?
I went for 1 week, and when we had the court December 3rd, she didn't get me the date. I asked, my mother-in-law was here. I think she didn't want me to know because she wanted Ayo and the mother-in-law to be there. I asked later, I said she would prefer Ayo and Miss Capus to be there. I asked before I traveled.
And did you at any time inquire of your wife regarding the bills associated with her surgery and with her radiation therapy?
Because I'm the one responsible for the insurance. BSCBC sent it to me before she gets there. I get the bill first, the insurance payout. Yeah, so I get it first. So I don't need to inquire.
Okay. And you agree that you didn't pay for those bills?
My insurance paid for them. It's all like 200, 300. Yeah. Then I will get the bill and then give it to her.
And what about the deductibles? Did you pay the deductibles for that?
No, but you mean the doctor outside the insurance?
Correct. The
No, I did not.
The insurance did not pay.
I did not.
Okay. And did you pay for any of her medications associated with that?
She had the card. She was using the card and she gave it back to me. There was a $1,000 bill on the card.
And you think what, the credit card or the prescription card?
They call it the P&G prescription card. Yeah, I put 1,000. Like every month, they withdraw something from my salary. So this has 1,000. You told me not to show it. So she just showed it at family fair and it will be paid for. She has the card. She left it.
And she testified that she didn't have the card.
She did. She left it. I'm not lying. She left the insurance card too.
Oh, she left it when okay.
Yeah, but she was still covered. She did not have it because you need to imagine, even the insurance card, if you already been in the system, you don't. But when she was leaving, she left it or send it through her king.
Does anyone reside with you besides your son?
Only me and my son, and he comes every other week.
Okay. And are you responsible for anyone's financial support other than your son?
What do you mean responsible for? To pay for what, please? To be specific.
Are you providing either of your adult children with financial support currently?
No, our lady is self-sustained. I just heard he's working at firekeepers. Only okay. We're talking about high deductible. I just have to pay $500 to go to the food insurance last week, as well as the segment 2. So aside of the money that's being removed from my salary, so it's the only one line.
I'm sorry. You
I
paid
said
$500
talking about the high deductible insurance. The Oakland hospital just sent me over $500 for this X-ray for his food insurance last week.
And
From football. I'm sorry.
Do you have a health savings account or any account of that sort that you could use for the deductible payments?
No, I just pay as I go. Yeah.
Okay. I have no further questions, Your Honor.
Sir, just to clarify, you have, I think you said the 2005 Kia, is that correct?
Me?
Yes, that you said is for your son, Akeem?
No, it's a 2013 Hyundai Elantra.
Okay.
2013. It was bought for Ayo. Ayo that came today. That's the car he left when he left 2 years ago. Then the 16-year-old is using it.
Okay, so it's a Hyundai?
Yes, a Hyundai Elantra. It's in the garage as I speak.
Okay. And you say you purchased it for about $6,500 about 4 years
Yes,
ago?
that was for, my wife and I went about 6,005 when Ayo was turning 16. That would be no, is it 16 or 18? Shalina, you remember we went to Detroit 4 years ago.
So you said about 4 years ago, correct?
Yes.
And so what do you believe to be the value for that vehicle?
When you factor in the depreciating value of cars, if we bought it about 6,005, because the mileage there is almost, we just did the oil change, almost 170. I don't know, except if I do the blue book, and it's had some scrapes and scratches. If you look at the condition, I can't, Your Honor, I'm not into car sales. I don't know the value.
Okay, so you have no idea then?
Believe me, I wouldn't want to lie. Yeah.
Okay.
It's been banked up. All right.
But that vehicle is in your name or is it in your wife's name?
It's in my name. It's in my name.
Yeah. Thank you. Let's go back to, you said that you've been putting about $100 a month into the bank in Nigeria.
Yes.
And you said that had a balance, let's say at the time of the filing, which would have been back in, say in May of this year.
Yeah.
That there was about $8,000 in that account.
The one even now is not up to 8,000. About that time we have barely $300 or $400. Like I said, I remit like $100 a month. Up to now, I don't have it 1,000 there.
Okay. Again, I didn't understand. So, how much does it have in the account as of the May 31st, 2024 date?
That's what I'm saying. It will be less than $400 or $500. I just opened it in January, so I started sending money in February, March, May, April, May. Let's say 400, because if I remit $100 and I have the proof, the cash app, I will share that.
Okay. Okay. Hold on. I want to get this really simple. So you say about $500 is what you're saying?
Yes, I will even agree to 500. Like it's 100 a month. So February, March, April, May, 400 or 500. Yes.
Okay. Okay. And you said that you had, at the time of filing, you had a CD with Homestead Bank of about 10,000 plus, correct?
It was like 7,000 there. I kept adding to it to like 15 now. At the time, my wife, as she said, was 7,000.
And that's what she said was in there. It was approximately 7,000, correct?
That's what I'm saying. Yeah. At the time she was living with 7. But I've increased. It's no longer that amount. I keep changing it. Yeah.
I got it.
Yes.
Okay. Okay. I have nothing further. Is there anything else, Ms. McNiff, as a result of my questioning?
No, Your Honor.
Okay. Thank you.
Can I add this question?
Okay. Go ahead.
Yeah, I don't know why we are not addressing my wife's 401k in light of discussing all this, what I have. What about our own 401k? When are we going to do that?
She's testified about the 401k.
She said he spent it. I don't recollect you questioning about how much was there, how much she spent. Is that not going to be part of the consideration?
She testified about that already.
All right.
Okay. Anything else, sir?
That is it.
Do you rest at this time?
I rest.
Okay, thank you. Ms. McNiff, any rebuttal?
No, Your Honor.
Okay. And that concludes the proofs in this matter. Ms. McNiff, closing argument.
Your Honor, we had thought that these parties were agreed on all issues except for the marital debts and spousal support. And we thought that as a result of that agreement that Mr. Olapide would receive the marital home subject to the debt, as well as his expensive 2020 Range Rover and the 2014 Hyundai Elantra, and the parties would, we had no testimony regarding other personal property, that the parties would just maintain the personal property in their respective possessions. We are asking for at least $100,000 equalization payment, which would both provide for an equalization of the equity in the marital home, an equalization for the parties' respective vehicles, and an equalization of the bank accounts. And we believe that that's a completely equitable settlement, and one that had been previously agreed to as well. My client currently has a 2006 van that is in bad shape. She's already had to expend money that she simply doesn't have to repair it. It's not a reliable vehicle for her to be able to travel back and forth to work once she finds a job, and she's going to need to replace that vehicle. So she's going to need funds in order to do that. Mrs. Lapide has been looking for work religiously, however, without any success. Her issues come from the fact that she does not have a Michigan teaching certificate. She's been working to try to see what she can arrange with other Michigan colleges to see if she can pick up the credits needed so that she would be able to get a Michigan teaching certificate. She's looked into jobs that would involve early childhood education that wouldn't need a teaching certificate, but would utilize her skills and her background and as well as her education. But to date, she simply hasn't been successful. The court heard her testimony regarding her job search, as well as the party's son saying that mom regularly does, in fact, look for work. Mrs. Lapide has had significant health issues that have impacted her ability to work and have required her to take time off from work without pay. While she is recovered and continues to recover from cancer and the surgery and the radiation treatment required from that condition, she also, of course, has Graves' disease and issues with diabetes, and as well as some cardiac issues. She needs health insurance because she has medications that she's required to take to maintain her health, and finding her own health insurance is going to be expensive. Without some, and she has no way to do that other than to possibly apply for Medicaid at this point until she's able to obtain a job in which she would be able to secure health insurance for herself. She currently has a rent payment of $1,000 per month, and she's also been racking up those vehicle repair bills. She's got approximately $35,000. Well, at the time of the divorce, she had approximately $35,000 in credit card debt. That amount has increased as the interest has increased, and she's been unable to make even the minimum payments on those credit cards. However, at the time of filing, we estimate that the total debt was $35,096. Most of that was accumulated when she had cancer and she was unable to work, but she wasn't being supported financially by her husband. He wasn't paying for those medical bills. He wasn't covering the expenses that the kids were incurring. And so she was putting those expenses regularly on a credit card, and without working and without having the ability to make large payments over and above the minimum payments, those credit cards became larger. Her testimony was that she used the card to pay for the medical expenses, and that she used the card to pay for basic household items for the kids, items for the family, groceries, gasoline, car repairs, things like that. Those are absolutely marital expenses, and that they should be split evenly between the parties. She made sure that the kids could participate in their extracurricular activities, their school trips, school clothes, school supplies, and all of those types of expenses. The past relations and conduct of the parties is sad, quite honestly. While Mrs. Lapide would look for thoughtful gifts for her husband, while she would try to be submissive to him and try to do as he said, he would respond by being abusive to her, calling her names, hitting her, waking her up in the middle of the night, being controlling, complaining that she didn't have a job that was good enough, or that she was working for somebody that he didn't like. There were constant complaints, and whatever she did simply wasn't good enough for him, to the point where he was arrested on 2 separate occasions for domestic violence. And we heard about another instance of domestic violence that she did not report, that the party's son observed. In addition, Mrs. Lapide reported other incidents before the children were born, incidents that they wouldn't have seen. But this has been a problem in this marriage for a long time. She testified that there was one occasion when she had to go to work with a black eye, and they had to try to explain that both to her work colleagues and to her doctor, who had concerns about her condition at that time. This is a long-term marriage. It's a marriage of 24 years. That should indicate to the court that a long-term spousal support award is appropriate. While defendant certainly has the ability to work and is currently working and is able to make trips to do research, plaintiff has struggled with her health problems in her ability to work with regard to having the proper certifications. When she has been able to work in recent years, she's only been able to earn $14 to $15 per hour, which even if she was working full time would be difficult for her to manage to support herself on and the party's minor child on that amount of money. And the small amount of child support that she receives along with that simply wouldn't be enough, even if she were working full time. However, she's not, and that's causing an incredible strain on her. Defendant right now has the security of a house, the security of a newer vehicle that doesn't require repairs, while the plaintiff is both renting and has a vehicle that's 19 years old. Both of these parties are in their 50s. They're not far apart in age. Age shouldn't be a major factor in the determination of spousal support. Defendant certainly has the ability to pay alimony. He was able to buy himself 2 different Mercedes-Benz vehicles. He was able to trade in one of those Mercedes-Benz for a Range Rover. Again, that's an expensive vehicle. If he needed to sell the Range Rover, have a less expensive vehicle, he would certainly free up his budget to be able to provide for more spousal support for his wife. He's been paying her $1,000 a month. He seems to be able to meet his financial obligations while still doing that. He's been able to travel overseas for vacations as well as research. And we believe that there's no reason why he can't continue to pay her spousal support and even increase the spousal support that he is paying. The court has heard a great deal of testimony over 2 days about the parties' current situations. Plaintiff testified extensively on her needs. She's frugal. She buys clothing at thrift stores. She doesn't spend a lot of money. She does what she can to try to conserve the funds that she does have, but she needs very basic things in life. She needs a roof over her head. She needs a safe vehicle. She needs health insurance. She needs groceries. She needs medications. And she needs help with that until she can find an appropriate job. The court has heard a great deal about the party's health, and I've already spoken about that. However, I would point out to the court that after 24 years of significant verbal and emotional and physical abuse, that type of constant stress is always going to have an effect on a person's health. Living under the constant fear that a person is going to be woken up at night, that she may be slapped in the face, she may be hit in the head, that these things could occur, that type of stress has a physical effect on the body. And we ask that the court take that into consideration when making a determination with regard to spousal support. Mrs. Olapide needs time to try to obtain health care and psychological care that will put her in a position of being stronger so that she can return to the workforce. The prior standard of living of the parties was a nice middle-class life. They went on vacations. They lived in, as Mr. Olapide said, one of the biggest, finest homes in here in Albion, a very nice house. You know, they were driving Mercedes-Benzes and Range Rovers. They were sending their children to college. And certainly it would be unjust and inequitable for Mr. Olapide to continue that nice life while Mrs. Olapide is struggling by with a 19-year-old car and barely enough money to make ends meet. Both of these parties have contributed to the joint estate. Mr. Olapide has had a traditional role. He's worked at his job. He's provided that type of income in order to purchase houses. Whereas Mrs. Olapide has also worked throughout the marriage. She has been able to provide health insurance through her various jobs for the family. She was able to earn an income that was contributed to the Ohio house and to supporting houses in Wisconsin and certainly the Michigan house. She took very little for herself financially, but put all of her money back into the home and the household and taking care of the children. In addition, she was the primary caretaker for all 3 of these children. She was the one who took them to activities, who oversaw the homework, who cooked for the family, who did most of the grocery shopping. She was the one who ensured that they had school supplies, that they went on their trips. She was the one who took them to church, for example, where Mr. Olapide was interrogating the children about how much money they were earning and terrorizing them over any imperceived slights or infractions, waking up the household in the middle of the night to make sure lights were turned off rather than just turning them off himself and letting everyone else sleep. Mrs. Olapide cooked, cleaned, took care of the kids, and work, whereas defendant primarily worked and expected plaintiff and the children to cater to his every need. He contributed what he had to the household, whereas Mrs. Olapide contributed everything that she had. There's absolutely no question, or there should be none, that defendant caused this divorce, that he is at fault for causing the divorce. The conviction for domestic violence, the arrest for domestic violence, the domestic violence that occurred in front of the party's son, Io, and the multiple incidents of cruel behavior towards his wife is what caused the breakdown of this marriage. He left the plaintiff to fend for herself while he traveled the world, including when she was facing surgery in order to resolve her cancer diagnosis. We can't be sure how much money Mr. Olapide has in Nigeria. We have his testimony. The idea of trying to subpoena a bank in Nigeria to get that information is almost impossible. But the very fact that he has sent funds to Nigeria and he admits that he does have, in fact, a Nigerian bank account, but resists supporting his wife is worthy of this court's consideration. Both of these parties are continuing to support their minor child, Akin, but neither of them is residing with any significant other in the effect of cohabitation other than with regard to the party's minor child. It should not be a factor here. Plaintiff does continue to assist the party's young adult son, Io, in terms of allowing him to reside with her while he is recovering still from his father's abuse on his own and trying to work and make his own way in the world. Your Honor, we are asking for the court to consider an award of at least $2,000 per month in spousal support for a significant period of time, certainly at least until Mrs. Olapide can find full-time work and possibly longer after that, depending on how much she's able to earn. We're also asking for attorney fees. She simply has no ability to pay attorney fees. Attorney fees are high in this case because Mr. Olapide was originally defaulted, although he was represented. His attorney did not file an answer, did not request an extension. We had to have a motion on that. There was also the issue of mediation. We had mediation scheduled for half a day. Mr. Olapide, much like on our first trial date, had failed to make arrangements at work and had to leave the mediation early, which caused difficulties in terms of our side believing and potentially his attorney thinking that we had a partial settlement agreement and then that settlement agreement not being carried through with due to the fact that Mr. Olapide left the mediation early and then contested the agreement that his attorney worked to put together as well. And that caused additional cost. As far as the first day of trial, Mr. Olapide, again, did not make the proper accommodations for his work, had to leave the trial early, and having to re-prepare for a hearing that occurred almost a month later, again, increased the costs. Currently, Mrs. Olapide owes this office over $10,000. We're asking that Mr. Olapide be required to pay at least $9,000 of that amount in attorney fees. We believe that this matter should have been settled at mediation and could have been settled at mediation had Mr. Olapide set aside the appropriate amount of time that was scheduled for mediation. Thank you, Your Honor.
Thank you. Mr. Olapide, your closing argument.
Thank you, Odo, for the opportunity to close. I would like to start where Attorney McNeeve ended, trying to blame me for the imperfect system. An attorney that I got that did not respond within the 3 weeks as requested, that I paid, and that I'm going after filing a grievance, or that did not inform me of all the documents he had regarding the financial situation that made me to not complete the mediation. It had nothing to do with my job that day. It was when they sprung the $42,000 on me that I said, why wasn't I told about this? And they told me I had some credit card statement. That was why I decided I would go to trial. During mediation, they were telling me that they know how you are going to rule. And I said, I do not believe in premeditation. I really want my own voice to be heard. The system was being piled against me because I am not a lawyer and I refuse to be shortchanged. Attorney McNeeve said I wasn't giving my wife support. What else is support? I paid all the bills. The only thing my wife paid was the Simple Energy, as specified by herself, our phone, and grocery that we share. I have the list here. I paid the mortgage, the car insurance, health insurance, house insurance, groceries, electric, cable, utilities, school-related fees. We share it. Kids' clothing, I have evidence. Yeah, if your honor want to see that. When we celebrate our birthday, we go to Olive Garden. It's so convenient that she forgot that on Ayo's birthday, we all go to Olive Garden. The last birthday before we separated, September 30th, because we are both born in September, I always take us out to celebrate. What is very glaring, and they are conveniently trying to model, is financial irresponsibility here. I have been here since 2006. Since I met Shalina in 1999, I've always stayed with the job I am with. Even when I left Milwaukee to go to Iowa, I did not miss a paycheck. We are talking about an adult with a master's degree that consistently will leave a job for no cause. And that brought up the issue of, I don't know whether she will call it abuse, that what will you do if you are single? What will pay the bills? This has consistently been the issue that we argue on. I mentioned Pastor Kendrick that died. This is not something that started from here. It started from Ohio. When I would say, you cannot just literally leave a job and not let me know. You cannot say you are my spouse and not let me know. she will always come up with one reason or the other. You really do not need to look far away. And if it's not the issue that I keep mentioning, cognitive dissonance, if somebody that need an insurance, claiming that she has lupus, has diabetes, will walk away from a $50,000 job where we are literally paying less insurance now that I pay. And let's stock me up with the family insurance, stock me up with the mortgage. We both signed another $20,000 mortgage to renovate the bathroom. Your Honor, you should remember that she left the safety of this home. When she locked me up when I was asking for my son, I went to get an attorney. I asked for my money back. She left without any notice, although she's been packing. She didn't have money. She's been putting things in storage for years, using that to threaten me. She not only weaponized my son. I mean, you should question, we have 3 kids. Why is it that only Ayo that disagreed with me having her to go to Albion College that is testifying today? She told me because she left Albion College, Ayo will not go to Albion College. And they went behind my back to get a school for him somewhere else. That is why I get all the messages of delinquencies. So, apart from, cognitive dissonance, the other one is responsibility. Responsible for job, responsible finances. I do not have my name on a credit card. She's not going to stick me to a bill that I do not know how she incurred. For law intended purposes, they only showed 5 months of statement. Like I told you, I can show you 7 years of my credit card statement. She even has them. We have everything in the basement. She took them. She took all the passport. The only passport in this house is my own passport. So the proofs are there. The proofs are in the building that somebody with a master's degree that has a bachelor's, repeatedly, you don't have to work, teach. If your excuses since 2004 is that you can't teach in Michigan, 2006. There are other jobs. I just shared with the court how somebody with PhD in genetics is an administrative secretary. There are other jobs she can do. Anytime I point job advert, she said I'm insulting her. When I say, your master's is in early childhood, use the house for the daycare. She will tell me the kids will bring in diseases. The parents will not come and get the kids. Albion, as we speak today, has daycare needs. We will be, taking money, dumping in the bank if we have 4 kids per month. She could do that now. Another financial responsibility has to do with where she's living now. She did not make, proper plans even if she wants to move out. Our mortgage is $740. Somebody that doesn't have a job went to get a $1,000 rent, and they want to stick that to me. Your Honor, we have to look at all the evidence. Do not stick to anything that did not have any cost to. I met her when she was doing her master's. I got married to her because I thought she was going to be responsible, got a good job and financially responsible. She even talked about health care. She was, she was caught with stage 1 cancer. She doesn't have cancer. She was caught when she got COVID. When I traveled, I came back and get her COVID. I've had sleep apnea since we moved here. She's the one that said, you wake me up. All I wake up. I did not because of that leave my job. I have high blood pressure. I have cholesterol. Tell me who among us is healthy. You cannot just continue to leave jobs. The examples are glaring and, looking at us in the face that this person is, not responsible, to take care of our finances. Why, when she claimed using court time to prove that we have joint account, hasn't she paid all these bills? Why did I not know about it? Again, Your Honor, where is the 401k? Somebody has a master's degree and doesn't have any retirement plan. I was told she spent $3,000 of the 401k. But I don't see any proof where I'm presenting mine. So it's glaring. Somebody is showing prudence, living within their means, telling how the finances. Another person is living beyond their means. Because you go to shop in cheap places, it's not an excuse. Do not buy what you can afford. Just like after spending over $10,000 on attorney fee, I'm representing myself. I can't afford it. Why is she piling up attorney fees and want me to pay for it? Why? It just doesn't make any sense. The same thing I said, do not go spend $800. When we have a home here, open house, people come in. All of Ayo's friends, they did it in their own house. She refuses. Your Honor, the Hyundai is here, nobody's driving it. If you think our 2006 car is old, she should come and take it. I've told her several times. Use this car. The Range Rover, you talk of the Mercedes. I went to get loans and I paid my loans. She can leave to court today and go to a dealership and pick a car and be paying. When I offered her, when she brought my sister-in-law, talking about that, my sister-in-law came to America a few years ago. She has an MBA, she's an accountant. She went to nursing school, she's making 5 figures. Shalina said she cannot do CNA or nursing because she can't stand blood. You cannot be merciful for somebody that's always coming for one excuses or the other. People will come. That's why we have increase in H1B. That's why I don't want America to happen to my son Ayo. Go study, work hard when you have support. Now he's working at firekeepers. 10 years now, he will blame his parents. The evidence is there. I've tried my best. Like I told you, I was raised to work hard, do what you have to do, and you will live good life. Now I'm married to somebody that I thought would be a support, that we sat down and agree, you just get a job, get an insurance, leave the other bills to me. I've held on to my part of the bargain. She's the one that kept leaving one job after the other. She complained when working with Nancy that she was maltreating her. I said, why are you even working for Nancy? She has a bachelor's in French. You have a master's. It's an NGO. I always respond to what you told me. You told me Albion College was maltreating you. That when they sent you to a meeting in Grand Rapids, they put you in a single hotel. They are wasting money. You and the person that went to share the same hotel. I said, listen to what they told you to do. She said IRS will come and close down the college. So we're dealing with somebody that's dealing with some, I don't know, I don't want to stigmatize. I've been working the same job. I've been holding up to the same bills I've been paying since left. The only thing I changed from my name and other evidence is the simple energy. I pay the other bills. So as I'm rounding up, we do not have a joint account. I knew I was dating. I've never had any joint account from Ohio to Wisconsin to Iowa to here. I've always maintained my individual account. I've always paid the major bills. As the way I was hardwired, I was raised. These $42,000, as I asked her, I have no idea. And they never proved anything. They just gave us January to May 2024 bills. It doesn't show, what the things was settled. And that was why I walk off, Your Honor. If you listen to the mediation recording, that was when I left. It has nothing to do with me not making plans for my job. And I appreciate accommodating me. That's December 3rd when I had to go give an exam. That was conditional. I wasn't told it would be an all day. I had to give an exam. You cannot change the exam at the college. Again, blame me, like she said, that I will leave and go to my job. I do not play with my job. The same place where I work for 19 years, she left after 1 year. Can you imagine what I went through to get tenure? Took me 7 years of battling, publication and things like that. I'm not blowing my own horn. It starts with that, and that's why I won this trial. Don't paint me as an abuser. For example, another thing she mentioned the day in Ohio that I made that to rent a car to come back. I was a postdoctoral scientist. We went for a Labor Day weekend. We've been partying all weekend. Janina, we need to leave. I need to present data to my advisor when we get to Milwaukee. We're talking about almost 10 hours drive. It was one reason after another. We have to wait. Somebody's coming. I told that any kid that wants to go with me, I'm going. You are at your mother's house. That's why I left. So when you just hear snapshots that are an abuse, I have to drive 10 hours. I have to go collect data that I have to present Tuesday morning after Labor Day weekend. She talked about me at the church, telling her not to talk my radio. We had a baby that was in the car seat for hours after church. She was talking in church, having a meeting. I turned on the AC. I couldn't leave the baby or lie to go in. I'm sending kids to her. She came in, she was laughing. I'm over the house. I said, your mom living in Ravenna. Go finish your meeting. So when you just hear a snapshot, you look at an abuse. I'm glad my mother-in-law came in December and said she only had noises. I correct my kids. You can blame me that I'm using the way I was raised to change them. Guess what? Attorney Martin didn't want me to tell her, that's my job. I see these kids every year. I've been seeing them since 1991. I've been teaching students since 1991. I know what I'm talking about. They don't start behaving the way they behave in college if you don't change them when they are younger. That's why I didn't want Ayo to go the wrong path. You can't put me in jail again for wanting my son to do the right thing. You can't. I'm not scared of jail. The 2 times I've slept in jail for 1K and asking for my son. So I don't even go anywhere. Ask my neighbor that knows all this thing now. They are hearing everything. So they want to put me as a bad guy because I want my kids to wake up and read, to wake up and do their chores, to remove headphone, so that they can sleep peacefully. I told her, don't go into the college politics so that you don't get into trouble. She said, I'm paranoid because I've been there before you, 18 years before that. So, Your Honor, what really messed everything up was I had leaving that job. When she said I told everything would never be the same again, I gave up. You are the one that's been complaining for years that you can't use your degree to work in Michigan. We fought, got you the job. Secure for 5 years, 50,000 plus. You walk away from it for frivolous reason. Now you're piling up debt that I had no knowledge about, and you have health condition. We were on working terms when I went to Colombia. You left health insurance, you left P&G for paying bills, you left everything, you walk away. She was calling my bluff, just like they called my bluff for Ayo. And I said, no, if you want to live the hard way, you are going to deal with it. I am doing my job. See, everything is vanity. All the issue of the house, I said so to the McLeaf. We are living in a beautiful house. I provided for my family. If she wants everything to be gone, let it be gone. I will be. The colleague just died January 1st. We are all going to live in this world and go back. It's not about money. It's about responsibility. This house is too big for me. My daughter, luckily, she's an engineer in Fort Wayne. She listens. Ayo, this is the blessing. Ayo's grade is all B's. I pick on them because I want them to do well. Before the police, before the system start messing up with them. System can mess you up. I pray my son will see reason that everything I do is out of tough love. I love my wife. I love that. I just couldn't stand being irresponsible. You don't need to look too far. It shows. Who is in debt now? Who needs that insurance that cannot pay for it? The car is there. She can come and pick the Hyundai tomorrow. I don't need it. I told the court I offered her the JLK. She said she doesn't want it because she doesn't want to be responsible for anything. I offered her $5,000 when she brought my mother-in-law, my sister-in-law, and my brother. My brother lives in Grand Rapids. Ashalina, I will write you a $5,000 check. If it's a joint account, why can't she write it herself? She's my car. Fuji was there, Bumi was here. She said it. They just bought a car. She said, I will give you $5,000. Go get the same car. I said it. Before I traded this car in, Shalina, take the GLK. I offer it to my daughter. I said, Olade, you have this $4,000 that the insurance pays you. Keep the money. Get the GLK. Olade said that the gas, I won't be able to maintain the gas. And I understand. So I'm not a guy that just go around living like a rap star, living because I drive a Range Rover. I'm 57 this year. I work hard. And I did not use family money there. I got the loan with my bank. I'm the one that has any direct association with the bank. If you think I'm lying, she should go to the bank tomorrow and prove that she has any, apart from the mortgage. She stuck me with that mortgage now that I'm paying. So I am human too. That's cause and effect. Instead of blaming me that wanted better thing for my family, you should ask an adult that should know better. What example are we living for our kids? Bills will not pay itself. Emotions will not pay your bills. Like I said, I have health issues too. And I sympathize with her. She knew she had that cancer when I had COVID and I gave it to her. That's how she knew when she was bleeding. Before my mother-in-law, before my uncle, I said, now when is your operation? She said, leave me alone. She was fighting. My mother-in-law was here and I had to travel. I've showed evidence that the trip I'm going to take to Japan next year, I've already been funded. It's part of all this money you see that I fix so that I don't spend it. I am obligated to do all these activities. My endowment, they gave me 10,000 to do all this research. So there are a lot of extraneous circumstances, there are a lot of things that I have no control over if I'm considered responsible. If I said I'm going to offer a course, I'm bound by that obligation. That's why I've been able to maintain. This is my 20th year starting. And then I will criticize, China, when did you leave your job? It will be a fight. Where's your 401k? You'll be a fight. Now you are, piling up 42. I never, to God who made me, I never knew anybody can be allowed to have $10,000 credit card. Because mine is my
Lapide, you're starting to, again, repeat yourself. So
I apologize.
Please stick to the issues and wind it up, please.
Yes. If I'd known there are all these debts, 20,000 on the roof, on the bathroom, about 10 or 18,000 because the came church on the roof within the same time. So I'm doing all the things because I take offense to that why somebody's contribute. I was jet lagging, jetting all over the place like the attorney presented. I'm a very responsible father. I'm a very responsible husband. And I have the record to show for it. Guess who doesn't? Guess who is in financial trouble? So if I did not cause any trouble, don't ask me to clean it up. Don't now that they want to associate with my financial responsibility, don't now club me with somebody's financial responsibility. The same thing I tell Ayo. If you don't, Olaide is already doing well. If you put yourself in trouble, don't look back. I've reached out to him several times. That's the car I bought for him. If Shakina wants it, it's not my car. She can come and get it. So the issue that you don't, it's my fault that you cannot change your car after I've offered to give you down payment, after I've offered my Mercedes that you thought I was living large on, and you say you can't maintain it. That's my fault. A husband is not a parent. It's a mutualistic, synergistic kind of relationship that it should be. Your Honor will hand that, please do not rod Paul to pay Peter. I know the court uses metrics to do all these calculations. I've tried my best. The 1,250 they are garnishing on my debt is already depletion because all the chairs, when she moved the furniture, I have to replace it with carpeting and everything. Do not put me in a financial strain that did not cause for myself. Again, she knew she had cancer when she moved out. So using her insurance bill not as an excuse, reside on her. She was covered by the insurance. She had a home. She didn't have to go and be paying $1,000 rent. Rent, not mortgage. The mortgage is
sir, you've already addressed this. Please wrap it up.
Yes, sir. Your Honor, I rest my case.
Okay, thank you. Ms. McNiff, anything else?
No, Your Honor.
Okay, thank you. Well, in this case, the court to note, we have heard the testimony from December 3rd, 2024, and today's date, January 3rd, 2025. And it's clear in this matter that, again, the parties have established a statutory basis for a breakdown of the marriage. And as a result, the court will grant a divorce in this case. I would state to the parties as I go through the various issues that what they have to understand is that the court is not able to resolve all the issues, conflicts, or problems that the parties had during the marriage, because it's just obviously that's not the court's job, nor am I able to do that. I'm simply able to divide up the assets, debts at the time of the granting of this particular matter, which would be the date of filing back on May 31st, 2024. Court would note that the issues concerning the child in this case was resolved by the parties. They both confirmed resolution of this matter at the commencement of the case back on December 3rd, 2024. In these cases, the court would note that credibility is always a consideration in every case. And oftentimes parties will allege the other party or a witness was not truthful or lying. However, the court has found that inconsistencies in testimony does not mean that an individual has lied. Conflicting testimony can occur as a result of the witness' background, perception, bias, understanding, misunderstanding, or a mistake. And when inconsistencies occur, the court will attempt to determine if they can be reconciled by other evidence or testimony. There was some conflicting testimony in this matter, so the court is having to make the best assessment that the court can as it relates to that. There has been various issues with concerning the property division that have been tried, and the court will address those individually as I go through. First job of the court in any case is to determine what property is marital and subject to division. The parties were married on September 9, 2000, and the complaint was filed on May 31st, 2024, and therefore the parties were married slightly less than 24 years. Marital property has been determined to be property accumulated through the joint efforts of the party during their marriage. Pursuant to Michigan compiled laws 552.19, the court must divide the property between the parties in a manner which is just and reasonable. A division of property need not be mathematically equal, but must be equitable. An equitable division is one that is roughly congruent, and there is no exhaustive list by the court to use to consider what is equitable. However, in the Sands v. Sands case, the Supreme Court held that the court must use its discretion considering all the circumstances. And in the Sparks v. Sparks case, the Supreme Court provided a non-exhaustive list, which the court can be used as it relates to spousal support, and that courts have adopted pretty much those factors as it relates to property division as well. A party is entitled to invade separate property if they contribute to the acquisition, improvement, or accumulation of that property. And if parties place separate funds into a joint account and therefore commingle it, the property is subject to division. In this case, I'm going to start with the real estate, the real property in this case. The parties have both testified that they moved about during the marriage based upon various schooling and jobs that the defendant had acquired. They had sold various houses. They had, in fact, taken that money to buy other houses and had, in fact, titled those houses and that real property in the joint names of the parties. It was believed that the property, which is the real estate that's in the parties' names, was going to be taken and by the defendant. However, during the course of this trial and on closing and testimony states he doesn't want that in fact he wants the property sold. So what the court will do is the court will order that the property be listed for sale within 21 days of today's date, that it be sold, and that the equity that the
You're just frozen.
Yeah, he is.
Okay. I thought that was the only one. It's
No.
snowing here. Maybe it's the snow.
Hopefully he'll come back.
All right.
But
we had a problem with our internet crash at the courthouse.
Yeah, it seemed like it because we could hear each other and you were just frozen.
for a moment we did, but it seems to be back now, but we'll see. Anyway, Judge, we're back on the record. You can continue.
I thought you were going to say something about we could see that your lips were moving, but we couldn't hear you. And unfortunately, I think I have that same problem at home at times with my wife. She sees my lips moving, but she doesn't hear anything.
It's selective hearing.
Yeah. Well, in this case, the court will note that the testimony has shown that both parties have worked at different times during the marriage and both contributed to the acquisition, improvement, and maintenance.
Judge, so when you froze, you had just said that the house would be listed for sale in 21 days.
Yes.
And that's all I got.
Okay. Well, what I've just stated now is what I went into. So there would be listed. Okay. What the court is saying is that in this matter, that it would be listed within 21 days when the property is sold, that the defendant will get a credit for all payments that he's made on the mortgage since May 31st, 2024 through the date of sale. And that, in fact, that would be credited to him out of the proceeds before dividing the balance equally between the parties, subject to later determination as I go through the rest of the property issues. As I stated then, the testimony has shown that both parties have worked at different times during the marriage and both contributed to the acquisition, improvement, and maintenance of the home and homes in this matter. Court believes that based upon all the equities in the case, that it is fair and equitable that the parties divide the equity equally, which I am going to do once it is sold. Next issue is the retirement and pensions. The defendant started working at Albion College during the marriage, and he acquired a retirement account with in excess of $33,000 as of the date of filing. Plaintiff had a retirement account of approximately $4,000, which she acquired during the marriage. In August 2023, the plaintiff withdrew the account balance and used the money to pay credit cards, groceries, some of her surgery expenses, as well as other family household expenses. The testimony is that she withdrew her retirement, and that is reflected in the 2023 tax return, which was submitted in this matter as, I think it was Exhibit 3 in this matter. The court will divide the defendant's retirement in half, with each party receiving one half as of the date of filing of the divorce, which is May 31st, 2024, pursuant to a qualified domestic relations order. the issue that parties have, the other issue, the following issues as it relates to personal property. The plaintiff will receive the Honda Odyssey vehicle of have a value of approximately $200. There's not been any contrary testimony or evidence about that value, and it's clear based upon the testimony of the plaintiff and her son as well that the vehicle is not in much of a good shape and in fact has little value, if any, so she'll take it at that value. The defendant had a 2020 Range Rover, which had a value of approximately $65,000. He traded that in for a Mercedes, which in which he owed approximately $55,000 left on the Range Rover, leaving a trade-in towards the Mercedes of $10,000. And as a result, the court will again order that $10,000 equity in the Range Rover would be divided, each of them receiving $5,000 from that equity. The defendant also has in his name a 2005 Hyundai Elantra, which was purchased approximately 4 years ago at an amount of $6,500. There's been no testimony about the current value in this matter, but the court believes that it is appropriate that it has a value in this matter, and the court, based upon other vehicles and things of that nature, would ascribe a value of $3,500 for this vehicle, and the defendant will keep that vehicle subject to a division of the $3,500, or each party receiving $1,750. Court would note that the testimony in this case is that the parties had a CD as well as an account at Homestead Bank, that the testimony was very extensive but somewhat convoluted and a little bit, I guess you'd say, confusing in this matter, but it does appear that when the plaintiff left the home, that in fact the amount in that account was divided between the parties equally. She took out half of that. She took out of that half some amount of money to, again, reimburse their daughter for a vehicle, that the funds were put into that account, and that was reflected in the recent exhibit that the defendant attempted to submit, in which he acknowledged that in fact that money was paid to the daughter to reimburse her for the vehicle that was actually her vehicle, although he was a joint owner, or he was a co-signer on the obligation on that. So
can I say something?
No, you can't, sir. I'm giving a ruling. And in additionally, the CD at Homestead was divided based upon that as well. So the court will find that the account and the CD at Homestead were divided, and there will be no further division of that. The defendant is receiving the household, or he was going to receive the house. Now he's not, but he is receiving the furniture, furnishings, and appliances in the property that, in fact, it sounded like based from the party said that obviously there's some value to that. Neither of the parties submitted any appraisals for the furniture, furnishings, and appliances, but the court does note in other cases, and numerous other cases, that those assets do have value, especially if you have to replace all of those, and that the replacement, when you're replacing stove, refrigerators, freezers, washer, dryers, TVs, furniture, beds, all that stuff can again raise up to a substantial amount of money. What the court is going to do is put a value on the furniture, furnishings, and appliances of $10,000 and award that to the defendant, and he is required to pay to the plaintiff 1/2 the value of that for those assets. Additionally, the defendant has testified that he has an account in Nigeria with approximately $500. The court will divide that between the parties, requiring him to pay the sum of $250 to the plaintiff. And the court will order that the equalization of those assets, Ms. McNiff, would be again paid to the plaintiff out of the house proceeds prior to division, prior to disbursement to the defendant of his half share after the credit he is to receive for the payments. In this particular case, the court would note that the next item the court will address is the spousal support. Spousal support is provided for under the Michigan compiled laws at 552.23, which provides, upon entry of a judgment of divorce or separate maintenance, if the estate and effects awarded to either party are insufficient for the suitable support and maintenance of either party, and any children of the marriage who are committed to the care and custody of either party. The court may also award to either party the part of the real or personal estate of either party and spousal support out of the real and personal estate to be paid to either party in gross or otherwise, as the court considers just and reasonable after considering the ability of either party to pay and the character and situation of the parties and all other circumstances in the case. As the court looks at the matter, the court would note that the court had entered a temporary order in this matter, providing the plaintiff with spousal support of $1,000 per month. The court will note that the court has to, based upon the Louts case or Sparks case, has to look at various factors in determining whether spousal support is appropriate. The first factor is the past relations and conduct of the parties. The plaintiff has alleged that on December 23rd, 2023, that the defendant assaulted her. He slapped her on the right side of the cheek, which resulted in red swollen marks on her face. Further, she testified that in June 2003, when she was pregnant, that she came home late and the defendant locked her out of the house, and claims that many times after that, the defendant locked her out of the bedroom. While in Wisconsin, the plaintiff testified that the defendant hit her, bruised her face, and said, "That's your punishment." In 2021, she claims the defendant hit her in the back of the head with his fist when she went to the pastor's house, and that's reflected in plaintiff's exhibit 17 and the marks from that. And she also testified sometime in 2016 that she fell asleep in a chair downstairs, and the defendant came downstairs and hit her in the face, and then defendant later apologized. In December of 2023, she claims that he slapped her, and he had to move out as a result of a no contact order till the case was over, and he pled guilty to that particular charge of domestic assault. Court will note that plaintiff's exhibit 18 shows the handprint on her neck from that assault. Court will note that the testimony of their son, Ike, today confirms that the other incident in which she was struck in the face, that occurred, and he witnessed that. So the court is taking that into consideration. The next factor the court has to look at is the length of the marriage. In this case, the parties were married 23 3/4 years, and the court is taking that into consideration. Next factor is the ability of the parties to work. There was no testimony in this matter that the defendant was not able to work. He is working full-time at Albion College and is capable of working full-time. He's not presented any evidence, although in his closing he had referenced some health issues that he had. But again, the closing is just argument, is not evidence, and the court will not consider that. Plaintiff testified that she has worked throughout the marriage and is attempting to find work. She's had significant health issues, some of which have been ameliorated, and the court will address these later as I address her particular health issues. But the court notes that she does have the ability to work and can work, although the court notes that based upon her having a master's degree, that she's always been underemployed, but she's taken work that she could get, and she's made anywhere from initially at $13 an hour up to $16 an hour. When she was under the grant at Albion College, she made approximately $25, but that was a limited time until, again, she wasn't able to. Next, the court has to look at the source and amount of property awarded to the parties, and is there income-producing property? There is not any income-producing property, but the court notes that there can be made income because the retirement that is being divided between the parties will, in fact, result in some interest on that particular money. She could move it, put it into other investment accounts or things of that nature. She could earn some income, but the court will note that it would not be substantial but the court is taking that into consideration. Next is the age of the parties. The plaintiff is 53, the defendant is 56. The next factor the court has to look at is the ability to pay. The court notes that the defendant's 2023 W-2 income shows that he made $79,592.95, that the plaintiff's income, if I calculate it at $16 per hour working full-time, would be approximately $32,000. Next, the court has to look at the present situation of the parties. The court will note that, again, now with not awarding the house to the defendant, that the parties are each going to have to, again, acquire housing, that the plaintiff currently has housing, which she shares with the minor child of the parties and also with their son, Akeem, who is working, and he is, again, residing there, and she is assisting him in that regard. Again, she is working somewhat. I think said she could work as a substitute and make approximately $16 per hour, although it is unclear at this particular point. Court will note that in the present situation, she does have health issues, and the next factor is the health of the parties. She has testified that she has Graves' disease, which results in tremors in her hand. She has had thyroid issues since her diagnosis of type 2 diabetes in 2019. She has been dealing with that. She's also had high blood pressure. And in June 12 of 2023, she was diagnosed with cancer of the uterus and had to undergo radiation to eliminate a tumor. And she was done with that treatment in September of 2023. However, she still has to have regular checkups in that. She's also testified that her Graves' disease has decreased and that her high blood pressure has improved as well. The court notes, as I stated previously, the defendant has not provided evidence of any health issues, so the court will not ascribe any to him. Next factor is the needs of the parties. The plaintiff has little income. She has set forth in her budget as Plaintiff's Exhibit 4 a substantial budget with approximately an expense of $3,811 as adjusted, as the court had deducted various gifts and other non-essential expenses from that. Court will note that the defendant has expenses as well, and he will have expenses if he has to go out and rent, etc. But the court does not know how much that may be. And as a result, the court's not going to speculate, but does note that he's going to have expenses as well. Next issue is fault. The court notes that when the defendant I can't remember if it was testimony or closing, where he was saying that yes, based upon his actions, which the plaintiff has alleged as fault, that he said he overreacted in this matter. But the court notes, aside from all of the alleged abusive acts, looking at the matter objectively, that the incident that occurred in December of 2023 was confirmed by his pleading to a domestic assault. And the court will note that the testimony of AO as well substantiate that in the years prior that the defendant had abused the plaintiff by striking her in the face. And the court will find in this matter that the defendant is at fault for the breakdown of the marriage. And I am taking that into consideration and determining whether spousal support is appropriate. The next factor the court has to look at is the prior standing of living. The court would note that the testimony of the parties shows that the parties did have a comfortable, although not lavish, lifestyle, that they had taken many vacations and many trips in this during the term of the marriage. That again, the defendant had testified about living in the home that they do, that it's a good home in a area of Albion that has higher end homes. The court would note that again, that they were able to send their kids to college. They were able to go to various camps that for the kids, for band, etc., that were more expense involved in that. So the court would note that the prior standing of living of the parties was well, that obviously in any case, when the parties get divorced and divide up assets and no longer have access to two incomes, that it does result in a decline in the lifestyle of both of the parties, and the court is taking that into consideration. Next is general principles of equity, and the court has taken those into consideration, looking at all of the evidence in this matter and to how it will impact both of the parties. And when I do that, the court does believe that it is appropriate that the court would continue spousal support in this matter, and the spousal support will continue at the rate of $1,000 per month until plaintiff reaches the age of 62, when she would qualify for Social Security benefits at the earliest qualification date, and that spousal support would terminate upon her death or remarriage if either of those were to occur. Next thing the court has to consider is the debts of the parties. The parties do have credit card debt as alleged by plaintiff, and at the Blue Ox Bank, that plaintiff had submitted Exhibit 6 with a date ending of May 28, 2024, showing a debt. I'll say these and I'll slow down if you want me to, Ms. McNeff. A debt of $4,963.48. That there's a credit card reflected in Exhibit 7, having a end date of April 24, 2024, at the Slate Credit Union. That has a debt of $23,096.01. There's also Exhibit 8, a credit card statement owed to Citibank Visa, showing a debt as of April 16, 2024, in the amount of $14,685.16, totaling $42,744.65. If the court were to divide this in half, that would mean that each party would owe $21,372.32. Court will note the testimony of both of the parties, and the testimony of the defendant was that both parties paid bills and expenses during the marriage, and both used credit cards to do so at different times. The defendant claims that he had a lack of knowledge about the credit cards that the plaintiff was using to pay household expenses, and that he shouldn't be responsible for the debts that he was not aware of. However, the court will note that notwithstanding the lack of knowledge, if in fact debt was incurred during the marriage, it is a marital debt subject to division. The plaintiff has introduced exhibits showing expenses of the children when they went to camp, and it shows that that was charged on the Visa account. She has shown statements showing that there were medical bills that were paid for the kids and for herself during the marriage. And the court would note that even if the defendant didn't know, it would appear reasonable that he should have known that with the meager income that the plaintiff had, that she was not able to maintain the household and all these expenses on that particular income. As a result, the court notes that it was reasonable to assume that that money was coming from someplace. And although he states, well, my background isn't to, again, to incur debt, et cetera, in that particular matter, still the fact is that they did incur that debt, and there's not been any showing by the defendant that she incurred excessive expenses for herself in this case. And in fact, the court would show or believe that just the opposite is true, that she's not been excessive. She says she's gotten clothing at secondhand stores, that she has done without. She hasn't taken lavish trips or anything of that nature. And as a result, the court does not attribute any, I guess you'd say, excessive spending on those credit cards to her, but that it was utilized for expenses of the family prior to the division of the property. So as a result, the court will order that the credit card debt be divided equally between the parties, each paying $21,372.32 plus interest at the credit card debt rate until paid in full. And the court would hold that that amount would be a lien against the proceeds to receive by the defendant from the sale of the home. And obviously that amount would come out, he would pay his half of that, and the credit cards do appear to be in the name of the plaintiff, so she could pay hers off over the term of whenever she can get those paid back. The next issue, I guess the final issue the court has to address, is attorney fees as requested by the plaintiff in this matter. The court would note that attorney fees are able to be apportioned or assessed against the party pursuant to Michigan compiled laws 522.13 parens 1 and Michigan Court Rule 3.206 parens D. Michigan follows the American rule, which provides that attorney fees are not recoverable unless especially allowed by statute, court rule, common law exception, or conduct pursuant to the Hanaway case. In this matter, the court must make a determination and determine whether the attorney fees in this matter, again, are reasonable. And the court notes that the petitioner has set forth and established that she has attorney fees in the amount of approximately $10,000, that those attorney fees were necessary to enable her to carry on and to proceed with the action in this case, and that she has stated that she is unable to bear the expenses to pay those particular attorney fees. It's clear, as she stated, that she obviously isn't paying the credit card debt, that the credit card debt was, in fact, she can't even make the minimum payments. The court notes when we looked at her budget that, again, she's not able to, again, pay the attorney fees in this matter. And the court will note that when we look at the factors in this case and the equities, the court does believe that an apportionment of attorney fees is appropriate in this case. Court notes in looking at the amount to be assessed in this matter, the court has to consider, again, the reasonableness of the hourly rate charged in that locality. The court notes that Ms. McNiff has, again, presented in prior cases her hourly rate when she's, again, sought attorney fees. The court notes that those appear to be within the range of the particular locality, and that court notes that although not providing a statement as to the hours expended, that the amount that she has stated have incurred in this case are not unreasonable based upon the actions taken in this particular matter. Court notes that the attorney fees then would establish a baseline subject to adjustment after the court looks at the following factors. Would representation in this case preclude other employment by the attorney? There's been no evidence or testimony about that. Again, the amount involved and the results obtained, the court will note that the court's already addressed that in the division of the assets. The time limitations caused by the client of the case, no more so than would it be a reasonable case, so the court doesn't consider that. Next is the difficulty of the case. In this case, although it's been difficult and the parties have not come to an agreement at the mediation, the court does not ascribe that to either party, and note that either the party has a right not to settle, and the court is not going to, again, make a determination that, again, that the defendant was in some way responsible for incurring those additional costs. He has every right to not settle the case, and he didn't in this case. Next, is the, length of the relationship. Obviously, there's been no testimony about that. In this case, it was not an ongoing attorney-client relationship. Does that require an adjustment? Experience and reputation and ability of the attorney. The court will note, again, in Ms. McNiff's practice, as well as what she has done over the years with this court, that again, she has demonstrated the experience and reputation and ability in these particular matters. So the court is taking that into consideration. This was not a fixed or contingent fee, and as a result, the court will not take that into consideration. But when the court looks at those factors as set forth in Smith and Cowrie at 4881 Mich 519 2008 case, in the Perk versus United Savers Auto Association at 499 Mich 269 2016 case, the court does believe that an award of attorney fees is appropriate in this matter, and an attempt to assist the plaintiff in this case. The defendant has alleged and wants the sum of $9,000. The court doesn't believe that that's appropriate. The court has adjusted that and would award to the plaintiff the sum of $5,000, being one half of the attorney fees. And that again would be a lien against the defendant's proceeds from the sale of the home as well. With that, I think that is the last matter that the court had to decide. I will ask Ms. McNiff, is there anything else that you believe the court needs to address or failed to address before we conclude this case?
No, Your Honor. I think I have everything I need for a judgment.
Okay, thank you.
Thank you.
I would ask that you then prepare the judgment and submit it. In this matter, you can submit it under a 7-day if you can get it in that quickly, or otherwise notice it up for entry.
If I work this weekend, I probably can.
Okay. Well, good. We'll give you something to do on the weekend.
Exactly.
Mr. Olapide, is there anything you believe the court has not addressed or needs to address before we conclude?
Yeah, I thought I have reservations with the pension split, given that there's no 50-50 consideration here. You split my own pension in half without any consideration that I don't have any access to hers. And then given that she doesn't have any kind of permanent disability, payment of spousal support for the next 8 years, if I do my calculation right, I think it's unjust. Do I have any process of appeal?
Well, that's not what I was asking. Not whether.
Oh, sorry, I didn't know what you are.
No,
Yes.
not that if you agree with it. If you disagree with the ruling of the court, you always have the right to appeal that to the Court of Appeals. I was asking if there was something you believe was not addressed that needed to be addressed in this matter. That's all.
Yeah,
Not in how it was addressed, but if I had left out any particular issue in the case.
yeah, you did leave out a lot of my own situation, I think, contingent on the fact that my evidence was not accepted. You said you are not aware of my health issues, despite the fact that I mentioned them. You are not aware of a lot of the financial situation I mentioned, which I submitted, but you said those documents were late, which were not my fault because I didn't get the notice of the deadline. So I thought that should be considered.
Well, that again, that's an issue you can take up with the Court of Appeals if you want.
Sure.
The court made a
Yeah,
ruling.
sure.
I made a ruling on that the other day when we had the motion hearing. So that's.
Can the court tell me the process of appeal, the deadline, so that I don't, since I'm not a lawyer, how does that work? Do I have to go through your court, or how do I get the appeal? I'm sure I have to get the judgment, then submit an appeal to the Court of Appeal.
You're going to have to get a judgment, and then you're going to have to file in this matter a claim of appeal.
All right.
Or by application for leave to appeal, depending on when you file it. So,
okay.
And that's under the court rule in this matter. And let me look that up so I can provide the exact court rule to you. It's in the appeals to the Court of Appeals is covered by Court Rules 7.201 and thereafter, and provides that you just simply look up those particular court rules, and that'll tell you when to file, how you have to file, because you'd have to file briefs and everything else in this matter as well. So you can look up the court rules and determine what you want to do. Okay?
Sounds good. But I will be getting the formal notification of the ruling in the mail.
What?
I will be getting a formal notification of this ruling in the mail before I do that.
No,
The
you
court
won't
will
get
send
any,
me
you
your-
won't get anything in the mail from the court on this. Ms. McNiff will prepare a judgment consistent with my ruling, and you'll get a copy of that.
That's what I mean. Yes.
Okay.
That's what I mean. Yeah.
Okay, that's what you get. Well, I wish both of you the best. I hope everything works out for you and you're free to go. Have a good day.
Thank you,
Thank
Your
you.
Honor.
Your Honor.
I am going to dispose of the exhibits, Ms. McNiff, unless you pick those up within 7 days.
Okay, thank you.
Thank you, Your Honor.